alert level. And if you actually look at the regulations, you see that they become almost shorter and less comprehensive as we move from each alert level to the next. So the question was, how relevant are the previous sets of regulations pre-amendment? So how relevant are the level 4 regulations vis-a-vis the level 3 and level 2 regulations, and as such as you work your way through? So essentially how the government has approached the amendment to the regulations is by inserting a new chapter to each previous set of regulations. So if you look at the regulations under alert level 4, when we move to alert level 3, instead of amending the entire alert level 4 regulations, they simply, or the government decided to just simply insert a specific chapter dealing with what you can and can't do under alert level 3. And the same has now happened under alert level 2. So the short answer there is, if a specific amendment or a specific chapter dealing with a particular alert level doesn't deal with certain issues or doesn't do away with certain restrictions that were mentioned in the previous sets of regulations, then you can assume that those specific provisions are still at play. So in essence, what that means is you have to read all the regulations together, and where the amendments to previous sets of regulations specifically do not mention or lessen restrictions on certain things, then the previous sets of regulations would still apply to that particular issue. So that is quite interesting if you look at the alert level 2 regulations, because me being one of these types of people, the first thing I did when the level 2 regulations came in is I went to go see what the provisions with regards to, for example, the sale of tobacco and alcohol products are. So you know what you can and can't do, because we know for a fact that obviously tobacco sales and tobacco product sales have now been recommenced under alert level 2. So I was expecting to find provisions in the alert level 2 regulation saying the ban on the sale of tobacco and tobacco products has now been done away with, but you're not going to find that. Oddly enough, the lifting of the ban on tobacco products has not been mentioned in the level 2 regulations at all. So the assumption there is if the particular regulations aimed at this particular alert level doesn't deal with something or doesn't specifically restrict that particular right, then that right is fully in force. So what I'm essentially saying is, if the alert level 2 regulations don't mention the ban on tobacco at all, then you can assume that that ban has been lifted.
Yeah, and I think, as we've noted before, these regulations are primarily a limitation of rights, and not, they are prohibitive legislation, not enabling legislation for most, for your average citizen, the member of the public. So, as Peter says, where you are not specifically told not to do something, you can assume the contrary, and that you are now free to do the activity that you had planned to do. Maybe just to add to that, just in terms of the structure of the current alert level, the chapter, we're now dealing with a new chapter in the regulations. That's chapter 5. Chapter 3 and chapter 4 dealt with, in chronological order, alert level 4 and alert level 3, whereas chapter 2 contains the general provisions applicable during the state of disaster. So in the position that we find ourselves now, we are primarily concerned with chapter 2, the general provisions, and chapter 5, the provisions specifically applicable during this alert level 2. In addition to amending the regulations, if you look at Government Notice 891, the notice which carried the amendment on the 17th of August, Minister Dlamini Zuma specifically brought into effect alert level 2 and stated that alert level 2 will apply nationally from 12 o'clock on 18 August 2020. And I think it's probably worth noting that from a disaster management point of view, the reason why the regulations, or presumably the reason why the regulations as a whole aren't amended as we go from stage to stage or alert level to alert level, is that there was this much threatened idea that different geographical and provincial areas or hotspots, designated hotspots, could move from different alert levels. So for example, there was quite a bit of talk earlier on that the Western Cape, experiencing an early peak of the pandemic, might be put onto alert level 4, alert level 5, something more restrictive, while the rest of the country had already moved on to alert level 2. At this stage, no specific province has been designated a hotspot such that it has not moved onto alert level 2. So as of 17 August, or I suppose 1 minute past midnight on 18th of August, we're all on alert level 2. Yeah, so I think that's sort of the general comments about the regulations dealt with. We won't be revisiting the regulations which we've already addressed in previous webinars, the sort of more general ones. What we will do is just be running through the amended regulations. What we've decided to do is just split them up quite conveniently. I'll be looking at regulations 49 to 56, and then Peter will be doing the more interesting ones and starting on regulation 57. I'm not going to be sharing my screen, but if you would like me to, please, I suppose you can drop it in the Q&A section, or yeah. So then turning to the specific regulations and starting off, I think regulation 50 is the first substantive amendment. So regulation 50 deals with the movement of persons. And if we compare that with the previous regulation 33, we've seen quite a substantial change. Regulation 33 essentially confined every person to their place of residence, but that was made subject to certain exceptions. If we look at the old regulation 33, so now no longer in effect, a person was only allowed to leave their place of residence to perform essential services or permitted services, to travel to and from work, to buy goods and services, to move children, and the notorious exercise limitation of regulation 33(1)(e), exercise between the hours of 6 a.m. and 6 p.m. Other allowances were to attend a place of worship, to attend a school, or travel for leisure purposes as allowed. The regulation on movement of persons, which we now find ourselves faced with, regulation 50, is a lot less prohibitive. The default position is that parties may move freely. And what regulation 50 now says is that every person is confined to his or her place of residence from 10 p.m. until 4 a.m. daily, except where a person has been granted a permit or to perform a service as listed under table 3, or is attending to a security or medical emergency. So there's a critical distinction here which must be drawn between the previous regulation 33, which gave persons limited abilities or limited reasons to leave their place of residence. Now the situation is quite different. You can leave your residence for almost any reason, for any reason, subject to the mandatory protocols in public places under regulation 51, and subject to the fact that the curfew is still in effect from 10 p.m. until 4 a.m. daily. I think similar to what Peter mentioned about the fact that tobacco sales were not specifically mentioned under these, so the reopening of alert level 2, where we look at things like exercise. Exercise was previously allowed subject to time and exceptions. Now, although not specifically mentioned, you are free to exercise as long as you do so outside of the hours of 10 p.m. and 4 a.m. And that sort of changing the default position of what you can and can't do really applies to any other activity which you might want to busy yourself about with. Peter, any comments on movement of persons?
No, not at this stage. I think, and I think you're obviously still getting to this, but chatting on where you can exercise, it's common knowledge that the majority of public spaces have now been reopened to the public. The majority of people can
Yeah.
now go and exercise on the beach or exercise at a public park. But what is very interesting is that the government has still introduced this issue of vigorous exercise. So you are absolved of the necessity of wearing a mask if you are exercising in a public space, provided that the exercise or the extent of the exercise that you're undertaking is vigorous. Quite strangely, and between Alert Level 3 and the Alert Level 2 regulations, the Minister of Health was supposed to deliver further directives which defined this term vigorous. And those have still not been forthcoming. So they've now been mentioned in the second set of regulations in a row, and we still have no idea as to what form of exercise would amount to that particular degree of exercise. What type of exercise is vigorous or not, and when are you required to wear a face mask when exercising in a public space or not? So yeah, just something to note there.
Exercise without a face mask at your own peril, and if doing so, do it vigorously.
Yeah.
I myself find that the exercise regulation, or found that the exercise regulation prohibiting exercise after 6 p.m. and before 6 a.m. was quite constrictive. I think for those of us working office jobs, the idea of leaving the office sometimes before 6 p.m. to get out and get back to your car before 6 p.m. was somewhat problematic. So I'm quite happy that more restrictive position has been taken away.
Yeah. Matt, just before we move on, I see we have a question on the curfew and the movement of persons. I'm just going to read it out loud so we can all hear it. Okay. Can I leave my place of residence outside the curfew hours for work, i.e. work only closes at 10 p.m.?
Yes, you may. So it's a very good question. The curfew is limited for, the curfew applies to all persons leaving their place of residence, except, and I read here from Regulation 50, where a person has been granted a permit, which corresponds with Form 2 of Annexure A. So if you quickly scroll down to Table 3, Form 2 Annexure A sets out essentially your place of work will have to endorse and sign a form authorizing you to be on the roads at that time. So yes, if your work causes you to be outside of your home during the curfew hours, you are able to do so. Peter, do you want to just knock that one off as being resolved?
Yep.
Okay, so moving on, mandatory protocols when in a public space. That's Regulation 51. Here we don't have anything new. This is a regulation which was echoed under the previous chapter. Essentially, when in a public place, all persons must wear face masks, and your persons may not be allowed to enter into a public place, use public transport, or enter into a public building if not wearing a face mask. This one's relatively simple, and as I said, not a big change from what we had before. Regulation 52 deals with the contentious issue of attendance of funerals. I think this has been I use the word contentious. I think it's been part of the national dialogue quite a lot. The idea that a person could be sick or in hospital and you couldn't visit them, but if they were to pass away, you and 25 or 30 or 40 or whatever it was at the time, relatives could essentially attend a party and commiserate. The new Regulation 52 is far less restrictive than the previous funeral regulation, which was Regulation 35. Regulation 35.1 set out various familial relationships which essentially limited which party, what type of person could attend a funeral. So I'm going to read them here just to compare it to the new regulation, but essentially the the persons who were allowed to attend funerals were limited to spouses, children, children-in-law, parent of the deceased, siblings, and grandparents of the deceased. So essentially, friends and more extended family relations were prohibited from attending funerals under the previous alert level 3. The new regulation 52 is far less restrictive and only really limits the funeral attendance to 50 persons, stating that such a funeral will not be regarded as a gathering. And then the same sort of adherence to health protocols and social distancing measures are applicable. And yeah, the only real limitation which has survived under alert level 2 now is that night vigils remain not allowed. So if, for example, the ANC were to celebrate a fallen struggle hero, this time it looks like they probably could do so, notwithstanding that not all of them are spouses, children, or parents of I'm going to get the name wrong, Andrew Mlangeni, sorry.
Let's just hope they pick their speakers better this time around.
Yeah. Okay, so unless there are questions on funerals, I'm going to push ahead to the new regulation 53, which is the eviction and demolition of places of residence. For those in litigation, I think you'll be buoyed by the new and, again, less restrictive alert level 2 provisions relating to evictions and demolitions of place of residence. I'm going to read regulation 53.1, or rather the latter part of it, but essentially a person may not be evicted unless a competent court has granted an order authorizing the eviction or demolition. Now, again, Peter, you and I spoke about this off air, but it's a bit of a strange stipulation to have that you can only evict in terms of a court order. We
exactly,
already know
when that happens naturally.
Yeah. So it's a little bit of a strange one, but it essentially confirms what we already know from the Prevention of Illegal Eviction Act, that a person may only be evicted in terms of a competent court order. There are regulations issued at 53.2, which essentially allow the court some sort of discretion to suspend or stay an order for eviction or demolition. And many of those are related to the state of the disaster. But again, it's really a sort of 180-degree turn or flipping on the head of what was in place, whereas under alert level 3 and alert level 4, there was a hard bar to evictions unless a court order granted it in some sort of special circumstance. Here we have it the other way, that unless there are special circumstances, the court will grant and will execute an order for eviction.
I think the sheriffs are going to be very, very busy during alert level 2.
It's about time. I think to a certain extent, regulation 53 can be read with regulation 54, and that's pertaining to rental housing. Some of these provisions seem to have sort of flown under the radar and perhaps haven't been as newsworthy as they should be. Essentially, the powers of the Rental Housing Tribunal established under the Rental Housing Act have been extended. And in terms of the Rental Housing Act, we have certain prohibited practices or unfair practices, which landlords are prohibited or discouraged from engaging in. And the breadth of unfair practices has now been expanded in terms of regulation 54.2. I think some of these are quite, or could prove quite contentious. As I said, I don't think they've received perhaps the newsworthy attention that they should have. So Regulation 54.2a is essentially declaring now the termination of services by a landlord to be an unfair practice. Now, that could be the ceasing of, providing electricity, providing water, providing refuse removal, other services which a landlord is usually called upon to allow access to for his tenant. And we have a situation now where a landlord may not terminate those services without providing reasonable notice and an opportunity to make representations. The landlord has to reasonably and in good faith make necessary arrangements to reach an agreement regarding alternative payments, and has to provide for ongoing provision of basic services during the national state of disaster. I'm just going to finish up the other provisions of Regulation 54.2, and then Peter, I'd like to get your thoughts on some of these. So 54.2b says that a landlord may not impose a penalty for late payment of rental where the default is caused by the disaster. That one, I think we'll put a pin in, I think also fairly contentious.
Yeah, definitely.
Regulation 54.2c, a landlord must engage reasonably and in good faith to make arrangements, and I'm going to read this verbatim, to cater for the exigencies of the disaster. I think that's incredibly wide-ranging and
very nice and broad and very nice vague. It's very.
And then even worse on the subject of vagueness, any other conduct prejudicing the ongoing occupancy of a place of residence, and any person, or prejudicing the ability of any person to comply with the applicable restrictions on movement. So I think, C and D, we have very vague legislation, which I think is, going to help hold the landlord over a barrel for needing or to engage with his tenant. If I look at 54.2a and b, we're in a position where a landlord may not be able to terminate services even though a tenant hasn't paid. And also a landlord would be precluded from imposing a penalty even where his rental or lease agreement provides for that penalty. And what I suppose concerns me more is that the wording used throughout this section is, where the default is caused by the disaster. Now, what exactly is caused by the disaster? It's one thing if I ran a hair salon and as a result of that, I couldn't pay my my rental, or perhaps lost out income. But where do you draw the line? Where do you, how does an enforcement officer or someone sitting in, as the rental housing tribunal declare that the default was caused by the disaster?
Because essentially what you're looking at now is that, under the previous regulations, if you use the example of you being a hairdresser, for example, you with regards to your commercial landlord, you could have quite easily raised the defense, or not particularly a defense, but the doctrine of force majeure, or impossibility of performance. And we have advised many clients of this particular issue and helped clients get some form of remission of commercial rent, or to suspend the reciprocal obligations of both parties under a commercial lease. What this now does is that it brings residential leases within the same kind of umbrella, where there is an easy, tailor-made, particularly vague defense created by regulation or by law for a tenant. And as you mentioned very aptly, Matt, how do you define what type of result or what form of payment prohibition is caused by the exigencies of the disaster? Where do you draw the line? I mean, ultimately, if you were going to create this type of provision in a regulation, at least attempt at setting the parameters of what a landlord is entitled to do, and under which circumstances a tenant is able to exercise his rights under this particular section. But leaving it as broad as it is, it's definitely going to create issues. especially if we find ourselves in a state of disaster that is going to be extended past the 15th of September, even further. So yeah, no, it definitely, to my mind, creates more difficulties than it does solve them.
Yeah, I see we have some questions coming in. I think if we can just, the one regards to interprovincial travel, and the other regards the position of a landlord. I think if it's all right, I realize we often run out of time on these things, but maybe let's push through the regulation that you and I had lined up to discuss. I realize that I'm running quite low on my allotted time, so let's get back to them. But I think, as I said earlier, Regulation 54 and 54.2 in particular, and sort of forcing the landlord's hand in some situations and really giving quite a bit of power to the tenant. I think that is going to prove controversial. Yeah. During this limited alert level 2, and yeah, I mean it's essentially a form of legislative recognition of impossibility of performance. But to my mind, they've sort of missed the point here in that the advice that we had given to clients during the lockdown and with regards to impossibility of performance was always that the impossibility is attached to the ability to perform in terms of the agreement, and not merely the inability to pay. The fact that you lost your job during COVID does, in a normal common law context, does absolutely nothing to your ability, your obligation to make payment in terms of your lease agreement. And essentially Regulation 54.2 has now sort of interrupted that basic common law position. Yeah. So it's just something to watch over the next sort of few weeks and months, and for so long as alert level 2 goes on.
Yeah, the other strange thing on that issue as well, Matt, is that if you do find yourself between a landlord and a tenant in a residential dispute, I mean, when is that type of matter gonna get to court or be heard before the rental housing tribunal? I mean, ultimately we could be back down to level 1, which I assume is life back to normal by the 15th of September. And
most likely not an alert level 2.
Exactly. So ultimately, whether you're going to be able to rely on the alert level 2 regulations at court when they technically no longer exist in a month's time is going to be another controversial issue. But one of those things I guess we have to move on.
I think for those tenants tuning in, please do not take this as advice to stop paying your landlord. Please err on the side of caution and make sure payments are made. Okay, well then pushing ahead to gatherings, also a very contentious topic throughout lockdown. I'm going to skip ahead to the bit that I find most exciting, and that is under Regulation 55.2K, a social event at a place of residence subject to a limitation of 10 visitors or less. So it's been one of the remarkable points of this lockdown that all gatherings were prohibited, and gatherings at a stage were defined as anything more than one person being at a place and at a particular time, which meant that I was, strictly speaking, prohibited from visiting my parents. I wasn't allowed to visit friends, but going, throughout this process, I could attend a work function with 50 colleagues. And if, God forbid, one of my family members were to have passed away, I could have attended a party with 50 other people. It was one of the regulations really didn't make sense to me. And it is really nice to see now that government has eased up on that. So social events, social visits at someone's place of residence and subject to a limitation of 10 visitors, a very welcome addition to our current situation.
Just a note on that, Matt. It's very interesting that the regulations utilize the word visitors and not attendees or persons. So, I mean, if you are a household of 5 or 6 people, does this particular sub-regulation allow you to have 10 visitors, or are the actual residents of the property to be included in that 10-minute limit? So, I mean, if you've got 8 people living on a property and you're allowed 10 visitors, then you can have a party with 18 people. So yeah, an interesting drafting note there.
It's an interesting note, and I know which way I will be leaning when the compliance officer attends my premises. Yeah, I think other sort of highlights from the gathering regulations, which are not actually, sorry, the gathering regulations as a whole aren't materially different from the previous gathering regulations. To a large extent, it's a gradual easing and a gradual opening, allowing more persons at certain events. Another fairly critical amendment is 55.2J, which now allows weddings subject to a limitation of 50 persons and directions issued by the relevant cabinet member. So while briefly noting that the relevant cabinet member, I can't imagine who that would be, has not yet issued any directions with regards to weddings, but it's been a particular note for certainly in Cape Town, with a fairly large and prominent wedding industry functioning as a destination wedding place of choice. The tourism and sort of eventing industry, which draws a fair amount of its income from weddings, has been absolutely decimated throughout the lockdown period. So although it's perhaps not up to the full sort of royal weddings that we might want to be attending, a return to some element of normality with a limitation of 50 persons. The other big change, certainly, which I would appreciate, is 55.2N, and the fact that fitness centers and gyms are now open, again, subject to a limitation of 50 persons or less. I think when this particular regulation was announced by Ramaphosa, the country breathed somewhat of a collective sigh of relief. You could almost hear people jumping in their cars to head down to the nearest Virgin Active. Now, the limitation of 50 persons is potentially contentious. Certainly for the larger gym operators able to accommodate, upwards of 500 people at a venue, and that's very much how they're built up. Exactly. And often more than enough for social distancing. So then the question must be asked, if I have a warehouse-sized facility, I'm able to ensure that there's hand sanitizer. I'm able to ensure that my attendees are spaced more than 1.5 meters, that my machines are being cleaned, and that everyone is wearing masks. Why should I be limited to 50 persons or less when, if we looked at the exercise regulations, people could go do, any form of exercise they wanted. The classic example under lockdown has been at the promenade. But essentially, we could have people engaging on unarmed combat on the promenade in droves of 1,000 at a time, and the compliance officers would not be able to do anything about it. Yet, if one of the big gym operators wanted to invite 51 people into their facilities, they would be in breach of the regulations. That's something to think about there. Not sure whether or not this particular regulation will survive scrutiny. Yeah.
Agreed.
The other sort of highlights coming out of gatherings is that for those of us who like to indulge in a Friday beer, bars, taverns, shebeens, and similar establishments have now been reopened and are open to the public, also subject to a limitation of 50 persons. And accommodation establishments and tour operators are now allowed to open, again, subject to the limitation, subject to a 50% limitation on the floor space available. Just to end off on the point of gatherings, we had a similar amendment came through in Alert Level 3, and that's that an enforcement officer, when considering a gathering, Under the previous, I believe it was alert level 4, an enforcement officer could arrive at a gathering and take steps to arrest or charge or detain parties at that gathering. Under alert level 3, that softened, and that same softening remains under alert level 2, and that's that an enforcement officer, when approaching a gathering, must first, as per paragraph A, order the persons at the gathering to disperse immediately, and only if the person refuses to disperse may they then take appropriate action subject to the Criminal Procedure Act, etc. So, we heard rather ridiculous stories of people being arrested for convening a gathering under alert level 4. That will now, those sort of stories will disappear, hopefully, as the enforcement officer must first satisfy paragraph A and order parties to disperse. The only other bit I had to report on, which is not particularly long, is that nightclubs are closed to the public. The one point that I did have to make there is that the regulations don't seem to deal sort of from a definition point of view with what would be considered a bar, a tavern, and a nightclub. I can imagine many nightclubs are now going to miraculously advertise themselves as bars or taverns. And in the absence of any further and clearer legislation, I don't see how an enforcement or compliance officer could argue to the contrary. Peter, that's my bit. To anyone who had questions, if you can just pop it through on the Q&A, we will deal with it later. But yeah, with my regulations done, it's over to you, Peter.
Cool, thanks, Matt. So I'm going to start with Regulation 57, which deals with the prohibition of initiation practices. So if you look at the wording of this particular regulation and how it was worded under the level 4 and level 3 regulations, not much has changed. And ultimately it comes down to the fact that initiation practices, whether it consists of traditional circumcisions or that form of thing, are all still prohibited. And I think the one inclusion in this particular provision is that a particular obligation has been placed on the National House of Traditional Leaders and provincial houses of traditional leaders to ensure that all traditional leaders within their particular jurisdiction or in their areas, along with traditional surgeons or traditional healers, do or are made aware of the prohibition and don't carry on with these types of practices despite the wording of the regulations. So not only are these particular initiation practices now confirmed again as being prohibited, but a positive obligation has been placed on the bodies and the individuals who are in control, who have authority in those types of traditional affairs spheres, to ensure that the particular stakeholders involved in conducting the actual initiation practices are duly advised of the prohibition and what they can and can't do with regards to those particular processes. Okay, then moving on to Regulation 58. Again, it's very much a duplication of a type of regulation that was present in the previous alert level directive. So you're looking at controlled visits by members of the public to certain institutions. So the ones that were mainly dealt with under the alert level 4 and alert level 3 regulations was the visitation by family members and individuals to prisoners in their holding cells and in their various visiting areas and that form of thing. So visitors or visits by members of the public to correctional centers, remand detention facilities, police holding cells, and military detention facilities is still prohibited. But there have been one or two additions to that list, one being health establishments and facilities, except if you are an individual receiving treatment at one of those facilities, and obviously subject to the standard health and safety protocols. And finally, in quite an interesting inclusion, the rational inclusion in my mind, is older persons' residential facilities. So you'd assume old age homes and retirement villages and those form of things. Visits by the public to those types of institutions, given the, what you would assume is the lower immunity levels of those particular individuals and existing comorbidities and those form of things, because you are dealing with elderly people. So the government has gone about seeking to restrict the amount of visitors that can go through those doors to visit those people. Again, the type of standard catch-all clause stating that visits to all these particular facilities that I've just mentioned will obviously be subject to further directives published by the Cabinet Minister responsible for that particular sphere of regulation. Then, interestingly, closure of borders. I think the majority of us are aware that the borders are still closed. We are not allowed to travel internationally, nor are we entitled to receive international visitors, sporting sides, or that form of thing. I recently read that our national women's cricket team were prevented or barred from traveling to England to attend or take part in a bilateral ODI series or one-day international series with the England women's team, which was a difficult pill to swallow, and there was a bit of consternation about that as well. But I think what that confirms for us is that there'll be very little wiggle room and very little exemption for anyone under these particular provisions right now. So just to expand on that particular regulation regarding the closure of the borders, this is Regulation 59. And it states that during the national state of disaster, all borders of the Republic must be closed, except under certain circumstances relating to ports of entry, which have been designated by the relevant cabinet minister for Home Affairs. And these ports are only entitled to remain open and process imports and exports under the following conditions. These are the transportation of fuel, cargo, and goods, the entry of foreign sea crew for the purposes of exchange of sea crew in the Republic, and then humanitarian operations, repatriations, evacuations, medical emergencies, and the movement of diplomatic staff from various international consulates and embassies and that form of thing. Then moving on to public transport, this is one of the more relevant sections of the regulations that I've been assigned to deal with. So before we go into this, there's been a very strict kind of distinction drawn between what is considered long distance travel and normal travel. So what has been defined in the regulations as long distance travel is any travel on whether on a public transport type of thing, for lack of a better word, that exceeds 200 kilometers. So as soon as your particular trip, whether it be in a bus or whether it be in a taxi, that form of thing, if it exceeds 200 kilometers, you're looking at long distance travel, and that has its own set of restrictions and limitations placed on the attendance or the amount of people that can be present in any one of those buses or taxis, etc. So let's move on. I'm going to just quickly deal with what type of travel is allowed, the extent of those of that particular travel, and what type of restrictions are placed on those forms of travel. So it seems like we are back to being able to travel inter and intra-provincially, whether on road or via air. Obviously, there will be certain restrictions as to the amount of people that can be present on any particular airplane, for example, at any one time. And there will obviously be unique and distinct health and safety protocols for every form of public transport. So a very pertinent one, and one that I think, given just the nature of South African society that we will be dealing with, is bus and taxi transport. There is obviously a concern on the part of government, and especially with regards to health and safety protocols, that now that there is going to be an influx of people traveling to and from work, now that most business sectors are entitled to recommence trading, there is obviously a concern that the public transport system may be overwhelmed, and also whether they have the capacity to ensure that this new influx of people traveling to and from work, if they are adequately protected by the necessary measures that public transporters have to take on these various forms of transport. So buses and taxi services may not carry more than 70% of their capacity for long distance travel. So as soon as your bus or your taxi is set to travel more than 200 kilometers, they are only entitled to take on 70% of their normal capacity. What this means for taxis is a different thing, because I think the standard capacity for taxis are about 15 people, but they normally go anywhere up to 25 or 30. So whether they will actually be compliant to that regulation in practice is going to be an interesting thing to see. Then obviously 100% capacity is allowed in bus and taxi travel for any distance under 200 kilometers. Beneficial one, and the one that we've all been looking forward to, is the new allowance.
Sorry, Peter.
Yeah.
I've been muted. I just wanted to note that we had a question from a Pierre Schuster,
Yes.
an anonymous attendee who did ask about interprovincial travel. And
Yes.
The question is, does a person need to go into isolation upon returning home from that travel? I figured we might as well deal with it now as we're on that section.
Exactly. Yeah. Well, I think ultimately the short answer to that is probably not, unless you know for a fact that you have come into contact with someone who is suspected of being a carrier of the virus or someone who has tested positive. Ultimately, with the interprovincial borders being opened, it would be somewhat counterproductive to require everyone that is returning from a trip, whether it be for leisure or for business, to self-isolate. So I would assume, and I think we can safely say, that just by virtue of the fact that you are traveling between provinces, that does not mean automatically that you have to place yourself into any form of self-isolation or quarantine when you return to your place of residence, only if there is a substantial opportunity or substantial chance that you came into contact with someone who is suspected of being a carrier of the disease, or if you know for a fact that you came into contact with someone that tested positive.
In which case, the specific regulations relating to isolation and quarantine, which I think are Regulation 7, would apply. So I think, yeah, the long and the short answer to that question, anonymous attendee, is that no interprovincial travel in and of itself does not require isolation or quarantine. Yeah, cool. Thanks, Peter.
That's it. Great. So as we all know, the sale of alcohol has been allowed, but very similar to that very short window of hope we had under the level 3 regulations, when alcohol sales were permitted for about 2 weeks before they were very cruelly and unexpectedly taken away. So alcohol sales at any license or any particular seller of alcohol that is an off-license type situation. So your normal bottle stores where you cannot actually sit down and enjoy your drink, they are only entitled to sell alcohol between the hours of 9 and 5, very similar to the restrictions under previous regulations, and only from Monday to Thursday. So given that it's 10 to 6, if any of you haven't yet stocked up on your drinks for the weekend, you'll only be able to do so on Monday again, unfortunately. So obviously there is a restriction if you are a bar or a shebeen or a tavern that is an unlicensed or an on-site licensed operation. There, the only limitation would be the national curfew. So you are entitled to sell alcohol for on-site consumption during your normal working hours, provided that those working hours do not exceed or go past 10 o'clock. So the limitation on the sale of alcohol for those that do not have on-site consumption type licenses is between 9 and 5 from Monday to Thursdays. And if you do have an on-site consumption license, you can essentially sell alcohol for consumption on-site Monday right through to Sunday, provided that you don't sell after 10 o'clock at night. Then moving on to the next amendment that I'm dealing with is the operation of the economic sector. Good news for most who have been prohibited from exercising or taking part in their particular trade under the lockdown and the various regulations is that most business sectors are now entitled to recommence their trade and to commence with trading. There are one or two caveats, obviously with anticipating a huge influx of employees back to their workplaces. So there has been a specific inclusion in the regulation dealing with employers who employ 100 plus employees. So in that situation, if you are an employer that that employs 100 plus employees, and where many of those employees find themselves in a shared space or in a type of bullring type cubicle setup, then you are required under the regulations to ensure that all 100 of those employees, for example, are not in attendance at work at any one time. So you are required to look at staggering work hours, looking at implementing some form of shift system, but just simply ensuring that your offices are not overwhelmed and that does not compromise the integrity of the workplace health and safety protocols that you are by law required to instill in your workplace. A similar type of inclusion has been made, and I would think this is a relatively common sense inclusion, would be that obviously special remedies and measures need to be taken if a specific employer has employees that exceed the age of 60. Obviously, those types of individuals are more likely to contract the disease, given that they may have existing comorbidities or some form of compromised immune system. So in those circumstances, it would still be recommended that employers have employees who have exceeded the age of 60 still work from home, if possible, or that they work in a specific part of the building at the workplace that does not necessarily allow for them to be in constant contact with other employees. Then I'm not going to go through the various provisions dealing with the compliance officer in the workplace and the role of the compliance officer and the compliance plan that needs to be drawn up with regards to the phasing in of employees' return to work. We have dealt with this in 2 of our previous webinars under the Alert Level 4 and Level 3 regulations, and they haven't changed much. Essentially, every workplace is still obliged to appoint a compliance officer, and that compliance officer is obliged to develop a plan, a written plan, dealing with the phasing in of the return of employees to the workplace, how many employees will be allowed at the workplace at any one time, when all employees in the workplace can be in attendance, the types of health and safety protocols in place in any workplace, and obviously the keeping of a written copy of that particular compliance plan to ensure that if an enforcement official or compliance officer does sneakily rock up at your door one day with a little surprise attack, you can ensure that you have the documentation to confirm your compliance.
If I might just, hang on. Sorry, Peter, if I might just jump in there. I think as with the bulk of the regulations issued under Alert Level 2, it's really a sort of a relaxation of regulations which were already in place.
Yeah.
And in respect of compliance officers and sort of in the employment and work environment, there has been a change. If you consider Alert Level 2's table of economic exclusions, it's a lot more open than it was previously. So the attitude now is that you may do any sort of work. Persons who are able to work from home must continue to do so. And work is really subject to health protocols, social distancing, etc. So there is a gradual sort of reopening and relaxation of the previous regulations.
Yeah, surely.
Okay, Peter.
No, that was actually going to be just my last point, was just to quickly discuss what business sectors and what type of businesses are still not entitled to trade, which we feel very sorry for, given that there's been a gradual relaxation return to business enterprises for most sectors. And these are, as Matt mentioned earlier, obviously nightclubs. The nightclub industry will not be entitled to operate, and I assume that is given the core hours that they trade. I think I remember from my studying days that the jawling at a nightclub only really gets going from about 10 or 11 o'clock onwards. And given the Level 2 regulations, we are all supposed to be nicely confined within the 4 walls of our homes at 10 o'clock. So as Matt mentioned, you'll probably find that a lot of nightclubs will now start opening their doors earlier and closing their doors before 10 and taking on more of a role of a tavern or a bar or a shebeen, whatever the case may be. Then obviously all international passenger airfare is not allowed. So those industries that operate in the international airfare travel for leisure purposes sphere will not be entitled to operate. Also the shipping for leisure, the cruise type operators, if they are looking at international travel for leisure purposes, they are also not entitled to operate. And then very sadly, any competitive sports events will not be, even though they are still able the type of provincial contests will still be able to run because there's no international travel required. But all international sporting events are barred, obviously, until our international borders have been opened. And if you are dealing with provincial competitions, then we also know that no spectators are allowed there, and only the teams themselves, their management teams, and journalists and those camera crews are allowed at the ground. No one else, unfortunately. So I think that's it from me, Matt. I think we've covered all the regulations.
Okay. If we could just, we seem to be plus minus on time. We did have 2 questions come through, which I said we'd try and deal with before the session ends. I think the first question from Pierre Schuster seems to have come through in relation to my comments on Regulation 54 and the sort of amended unfair practices of the Rental Housing Act. And Pierre's question is, what is the legal position of the landlord if he himself can show loss of income and, as a result, is unable to provide the services to his tenant resulting from the state of disaster? So in a common law position, if a landlord is unable to provide services, and I think maybe for the purpose of this discussion, let's limit it to electricity and water sanitation. These are services which are often provided for in the rental agreement, and if a tenant is not paying for those services, the landlord is in limited circumstances allowed to stop providing those. This regulation 54, I think, is going to very much muddy the waters, because I think it's very reasonable that there will be landlords out there who are now unable to provide services to the tenants like electricity and water, especially where we have a tenant that's not paying. What I do see at Regulation 54.2c is somewhat of a saving provision, in that tenants themselves are charged with engaging reasonably and in good faith to make arrangements to cater for the exigencies of the disaster. So perhaps it could be said that tenants have an obligation to engage with the landlord, so perhaps to limit payments of rental and to prioritize payments made to electricity, water, etc. As I said, I think it's going to be very difficult to deal with these. I think the Rental Housing Tribunal is potentially going to be overrun with these sort of matters. You can imagine a lot of people who've lost their livelihoods, who've lost their income, are going to be battling to pay rental. I know that in a sort of an eviction context where landlords can be accused of unlawfully preventing access to electricity and water, a landlord is able to approach a court and get an order against a tenant to to essentially stop or limit the supply of electricity and water to the sort of constitutional minimum. Not particularly helpful if you're battling with turnover to incur the cost of a high court application, but in theory there is recourse there. I consider that question answered live, Pierre. Sorry, it's not a particularly helpful answer. These regulations are sort of 2 days old, so I think the quagmire brought on by Regulation 54.2 is still very much fresh to us.
Just on that as well, Pierre, must also be remembered that if we're dealing with a commercial lease, for example, the issue of force majeure or impossibility of performance works both ways. So if for some reason the landlord himself can't render services because of the impact of the regulations themselves, for example, if there's a prohibition on a particular service or the type of industry in which the tenant finds itself, and they themselves can raise that particular doctrine, because the effect of the doctrine of force majeure or impossibility of performance is to suspend reciprocal performance, not just performance from one side. So that remedy, especially in the context of a commercial lease, is still available to you. Obviously, provided that the impossibility is true and that it is a legal impossibility enforced through the regulations.
Thanks, Peter. We have one more question, which I think, unless someone else sends through, we will close on. The question here is, if a particular cabinet member has not issued directions, can the business continue as per only what the regulations say? The question goes on to say that there are conversations happening behind the scenes which are not the law of general application. So can we ignore utterances from a department official if it is not a formal direction from a minister? So I think, sort of working backwards there, I would always ignore utterances from a department official if it is not a formal direction from a minister. When Ramaphosa made his announcement on Saturday at 8 p.m., the bars did not immediately open. They only did so after the regulations were issued and published on the 17th, and actually they only came into effect on the 18th. So
yeah,
I think for my part, it's been one of the more annoying features of this lockdown is that there's often been a lag between what was announced by government and what actually came into effect. And sometimes there was a glaring inconsistency. The notorious one was Ramaphosa going on stage on a Saturday telling us all, or telling smokers, that they would be able to buy cigarettes in the following week. And Dlamini Zuma famously, I don't want to say went around his back, but published regulations which outlawed or continued to outlaw the sale of tobacco products.
And yeah, I mean, there have been other examples of missteps that have happened very similarly. I mean, if you think about it recently, I can't remember exactly which cabinet minister it was. I actually believe it may have been Bekele, where he mentioned that if you are an individual not wearing a face mask in public, then you could be arrested for that. And I mean, that if you look at the regulations, that is completely wrong. It's not a criminal offense to not wear a face mask in public. It wasn't under the previous regulations when that statement was made anyway. And I think a similar statement was also made by Bekele, where he mentioned that smoking itself is not allowed under the regulations, and that simply was just incorrect. So I mean, to bring that back to the question, those are utterances by individuals who were not responsible for the actual preparation of the regulations when they were issued. So it comes down to a simple fact: you only have to comply with what has been stated in the published law. Anything mentioned over and above that in a public space by a person being a member of the executive, that it doesn't apply unless it's actually been reduced and passed into law.
Yeah, and then I think just to tie up the sort of first part of that question, if a cabinet member has not issued directions, can the business continue as per only what the regulations say? And at the beginning of this webinar, we discussed the idea that these regulations are really an instance of a limitation on normal rights. So in other words, where the regulations do not deal specifically with an activity, then you're going to take it that activity continues to be allowed and continues to be permissible. In other words, unless the regulations say otherwise, I would say yes, you can continue. A business can continue until such time as directions come out to tell you otherwise. I suppose the exception would be if the regulations said something to the effect of upon the issue of directions, a business may, which as far as I can tell is not present in the new chapter 5, which we are dealing with under alert level 2. Peter, anything further from your side?
No, nothing from me.
Okay, perfect. Well, thanks everyone so much for joining us. This was, I think, webinar number 8 in our series. We will continue to put these out from time to time as further regulations are published. Good luck and enjoy alert level 2. Thanks for joining us. Thanks, Peter.
Good. Thanks, everyone. Thanks, Matt.